My name is Shannon Sadowski. I'm one of a two-person firm in Cambridge. And so we do intellectual property and business law. So basically all we do is startups. And my specialization is intellectual property, which we'll go over really quickly. But my passion is music. I am a musician by training. I'm a classically trained flutist. And I gave that up to practice law. I've been doing this for 6 years, and so we're going to try and cover some of the basics of things that you guys should think about, because unfortunately we don't get to be creative 100% of the time, and there's a business and logistical aspect of what we do as creative individuals. So we're going to try and get through some of that. All right. So a lot of what you guys do and what you're going to try and protect, you can't touch. You can hear it, you can see it a lot of times, but you usually can't touch it. And so what we call it intellectual property, or intangible goods. So the number one thing that you guys need to understand is that no matter what you do and no matter what you create, you cannot protect an idea. What intellectual property is it's how you express that idea that you had, okay? So there are different areas of intellectual property that protect different things. They cross over sometimes, but usually they're pretty distinct. So what you guys as musicians are probably going to be dealing with primarily is copyright and maybe a little bit of trademark. So I'm just going to kind of knock out patent and trade secrets because we're not going to be covering those. But I just want to kind of try and put a little bit of context around that. So what patent protects is it protects processes, methodologies, inventions, formulas, designs, genetics now. It's pretty crazy. It's the most difficult bit of protection to get. And it's the most restrictive. So it's really important that going forward that you use the right terms when you're talking to people about what you're trying to protect. Is you're very rarely dealing with patents. So this is, for lack of a better word, it's a lot with science and technology. Inventions are usually protected by patents. So trade secret is kind of treated as an alternative to patent. So it's the same idea where it's kind of something that gives you a competitive advantage, but patent has finite protection. So it has a really short lifespan. So it's only 30 years. So like, for example, when you see like generic drugs, that's because the patent has expired on that drug and then anybody in the marketplace can use it. And in order to get a patent, you actually have to disclose it publicly. And some companies choose not to do that so they can keep their secret indefinitely. The best example of this is the formula for Coca-Cola. They decided to do it as a trade secret. This is actually pretty common in like the food and beverage industry. They don't want to disclose it, and as long as you separate it and it constantly gives you a competitive advantage, you can actually keep it indefinitely. So some folks opt for that. Trademark, which I'm hoping that we can get to, is actually a visual representation of the source of something. So trademark versus copyright is a really, really important distinction for you guys, because trademark is like your brand. Like say you always go to the grocery store and you're like, man, I really love how Clorox bleach gets my whitest whites. And you're always going to buy Clorox bleach because you feel like it's a really great thing. The thing is, it's a consistent experience for you. And so you're going to pick something up based on a name or some kind of symbol. And that is actually dictated by the customer. Trademark protection is actually driven by the consumer and not by the person that actually thought up the trademark. So we'll go over hopefully a little bit of that, because a lot of what you guys do, especially if you're in any kind of band or group organization, you probably have a name. You might have a logo or a design to go with it that actually does have value. And then copyright, which is the main thing that we're going to be covering, is the expression of artistic ideas, which is, hey, I have this great idea for something and I'm going to express it in some kind of artistic form that certainly has value, and don't ever let anybody tell you otherwise. Okay, so like I said, they do overlap in some circumstances, but we're going to just treat them as different for right now. So copyright covers very distinct areas of artistic expression. So music, visual art, visual works, including art. And by art, I don't mean it has to be good. I mean it just has to qualify as a drawer. It covers choreography, literature, film, and blueprints. Very nuanced area of copyright law. It is the easiest thing to get. You don't have to be good at what you do. You just have to qualify as some creative, what they call spark in law, and that qualifies. For example, the phone book is copyrighted because it's actually the organization of the names that is the quote-unquote creative spark. And something like the Sprint Yellow Pages, they've actually sued people because they put like Easter eggs in the phone book. And so if someone plagiarizes their phone book and they see the fake names in it, they'll actually sue people for that. So it's definitely the easiest thing to get, but the enforcement is really burdensome because it falls on the copyright owner. So if you're the creator of that musical work, you have to call that person out. You have to prove that they infringed on your copyright, which is a little bit crappy, but that's how we deal with copyright in the US. So, you kind of see these examples of, really good example is Urban Outfitters, for example. I'm just gonna say it. They make money off of ripping off of artists that can't afford to sue them. So for anything, for t-shirt, I mean, you guys know this. For t-shirt design, there was a thing about Christmas ornaments and stuff like that, because it is really difficult and really expensive to enforce your copyright. So although it's easy to get and it's inexpensive to get, as I'll show you guys, it's really burdensome to enforce. So unfortunately, unless you know some tricks, which hopefully I'm going to try and teach you, sometimes it can be more than it's actually worth, which is crummy. So the really important thing about copyright for you guys to understand, especially as music creators, is that it has a finite number of rights. So you want to think about it as kind of a bundle of sticks, all right? So you have 6 sticks, and these are the only sticks that you have to give away. So it's the right to copy, distribute, publicly display, so like in a public place, we'll go over a little bit what that means, publicly perform, again, like not in your living room, digital transmission, which is kind of a weird carve-out, and then also derivative works. And you have separate licenses for each of these. So when you're thinking about your musical work, you want to think about what you actually want or need to give away for something. So copy and distribute are kind of givens. This is anytime you give out your work. So if any of you have ever uploaded your songs onto iTunes, for example, they're definitely going to get the right to copy and to distribute. And copy we mean in not necessarily like a photocopy machine, like we mean digitally now, and also distribute digitally as well. So public display, not so much with music, but publicly perform, definitely a really big deal. I think the number one thing if you're a performer that you guys need to keep in mind is that it's public performance is actually the job of the venue. So I get a lot of questions about like, hey, I would love to cover this X song. Like, what do I have to do to cover the song if I'm gonna play it at a venue? If you're playing it live, totally not your problem. You're definitely the venue's problem. Play whatever you want. You don't have to do a single original if you want to. Now, if you want to record it, that's a different story. And digital transmission covers online work, so basically anything but terrestrial radio, which is a really weird carve-out in copyright law. So basically when this went into play, radio lobbied against this and got the carve-out, which basically screwed online streaming to their benefit. So when you hear a song on the radio, certain people actually don't get paid for that. But when you hear a song online, people do get paid for that. And then derivative works are when you change the essence of a song. So let's say you have, I don't know, a Beck song, and you'd really like to do a quartet string arrangement of it. That's considered a derivative work. So that's not a cover, because you're actually changing the essence of what the work is. Versus if you're a metal band and you want to cover Metallica, then that's not considered a derivative because you're not changing it in any way. So the important thing to remember is that there are separate licenses for each of these things. So it's really important that when you're examining if someone wants to distribute your work or if someone wants to license it, you very, very rarely want to give away exclusive rights. There's very, very small circumstances where you would grant that. You almost always want to give away non-exclusive rights, which is basically making copies of your sticks. Non-exclusive rights can be given away again and again and again. If you give someone the exclusive right to copy and distribute, which would probably be the case if you enter a recording agreement, for example, you're not going to be able to give that right to anybody else. So you want to be really careful about that kind of stuff when you're starting to create contracts. So term of copyright, your life plus 70 years. And then it goes into the public domain. So right now, the schedule that we're operating on is anything that was written before 1922 is in the public domain. Anything afterward, you have to get a license for it. Now, there are exceptions to that, which are coming more into play now because people are setting up holding companies for their music. So if you choose to write your music and then you put it into like an LLC or something like that, when the corporate entity owns the music, there's actually a different duration of copyright, which is 95 years from creation. And so most of you will probably hold things in a company and not hold them personally. So it's a shorter period of time, but honestly, from a realistic perspective, I still think 95 years is great. So when you do work for hire, and that also applies if you're a freelancer or if you're a session musician or something like that, you're not going to own it to begin with. The company that hired you to do it is going to own it, and then that copyright will be 95 years instead. And then anything that was recorded before 1972 actually falls under state copyright. So we're really not going to discuss that really any further. If you're planning on sampling something before 1972, you can email me. Yeah, great. All right. Really important stuff for you guys is that almost always, whether you created it yourself or you're planning on licensing something, copyrights have almost always two copyrights involved. There is the composition, which if we're thinking about a physical embodiment of that, that's probably the sheet music. Okay, a lot of times we don't have physical embodiments of it now, but it's the actual underlying song. So if you think of like songwriters versus performers. For example, Britney Spears sits in a room and listens to other people that wrote songs, and then she picks them and she records them. She's not the owner of the composition. The person that has the demo, they're the owner of the composition. So you've got the actual composition, and then you've got that one-time sound recording. So every time there's a new recording of a song, you have a new copyright. But it still embodies that underlying piece of sheet music, if you will. And I will say that there's a lot more money involved in So usually the way that this is treated is that once you get signed, usually your publisher will ask you to transfer those compositions to them. And if you have prior sound recordings, or if you're signing a record contract to actually record, usually your recording company will own the actual sound recording, but you will retain the right to the composition underneath, which is really, really important because this sound recording is only that one capture of that one time that the piece was played. The composition can be reinvented and redone differently every single time, so there's a lot of value in that underlying sound recording. So certainly if you're composing music, once it's kind of set, it has a lot of value because anytime somebody wants to record it, they have to ask you, with some exceptions. I should say they have to pay you. So the one time they don't have to ask you is that once you publish a piece of music, the first time it's introduced to the public, it's considered published. There's nothing formal that's involved there. But once it is introduced publicly, there's a statutory right involved with it. It's called a mechanical. I don't know if you guys have ever heard of this, mechanical rights. So once you do that, then anyone is allowed to cover that song. All they have to do is pay you for it. And so what they get is the right to copy and distribute. And this works to other people's benefits too. Because if you want to cover something and you want to release it, then what you can actually do is you can go through a third-party agency and they'll give you a price quote for it, and you tap, 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 and you pay that price quote, and then you're allowed to do whatever you asked to do. So Harry Fox Agency was typically the agency that took care of these things, but they give you these really complicated like revenue royalty sheets, and they're really confusing. Go to Songfile. If you want to cover something, just go to Songfile. They're really great. Their rates are really competitive, and say for example, and they divide it out. So say for example, you're not going to press anything physical at all. You're not going to do a physical distribution at all. You're only going to sign up for iTunes, and you're going to do it based on downloads. You can pay like a lump fee for like, hey, this will cover 3,000 downloads, and then iTunes will let you know when you got to that 3,000 point, and then you would be responsible for going back to Soundfile and being like, hey, this is so awesome, I got here, but I need to license it further. So they're really good with breaking it down, because there are actually different rates based on how the music is used. So if it's permanently downloaded, there's a specific rate for it. If it's streamed, if it's done on like a Spotify or something like that, there's a different rate for it. And you as the person that want to cover that song, you're responsible for making sure that you get all those rights. So the burden falls a bit on your shoulders if you want to cover something. But the good thing is that you don't have to ask anybody. All you have to do is go through kind of this third-party software, and you'll be given the right to it. But anything else, basically besides covers, you have to find the original copyright owner, which could be multiple people. Because again, if we're going back to 2 copyrights, if you want to do the composition, you have to go back to one person. It's usually a publishing company. If it's something that you want to cover, it's probably covered by a publishing company. But if you want to sample something, you always have to get both. There's no getting around the composition at all. You always have to license that. But if you want to use a sound recording, you also have to track down who wants a sound recording. Like fingers crossed, it's a recording company that you can actually get a hold of that has a licensing department. That's not always the case. People will license things straight on their websites if they're not signed. So you have to track that person down, and everything is 100% negotiable. It's kind of like, at least with what I do, it's kind of like buying a domain. You go in and they're like, so-and-so is selling this domain for $10,000, and you're like, that seems ridiculous. But, I mean, you can either say yes or no. So if you want to do something else with it besides a cover, you have to track down, and you have to actually negotiate a rate. Sorry, I was trying to demonstrate that, like, happy birthday, actually, it's not still under copyright, but it's still a good example, which is like the sheet music for happy birthday, and then tons of people have obviously recorded happy birthday. But this is a really good example of how you don't see things in public. So public performance, have you guys ever been to like a restaurant where they like sing happy birthday to people, only they don't sing happy birthday? They're like, happy birthday, no one? Okay. They do that because they don't want to license happy birthday because it's ridiculously expensive. So because it's a public place, they actually have to pay something different.
So many restaurants are starting that role.
And they do. And you know what's really weird about this whole thing? So if you guys are composers, you might have heard of ASCAP or BMI. They're performing arts organizations. So you want to sign up for them, because basically what they do is when you sign up, they have these algorithms that work in the background that calculate how often they probably think that your music was played. Okay, it's not a totally exact science, but it's actually based on like real manpower. So they actually have scouts that go out, and their job is to sit at bars and record set lists. So before I became a lawyer, I actually applied to do this. I got denied, which is really odd, considering now I'm a music lawyer. So they record the set list, and then they'll go and basically narc back to ASCAP and be like, hey, here are the things that were played. This person doesn't have a license. And so then you will get a letter, if you're a business owner, from ASCAP and BMI, and they will be like, hey, this is how, it's crazy. And they've been doing this in Boston, by the way, lately, specifically with yoga studios, and I've been working with a lot of yoga studios who are like, what is going on? And I'm like, well, in the statute, it actually comes down to like, how many televisions do you have? How much square footage do you have? How many speakers do you have? It actually comes down to this. I don't know who drafted that, but they weren't a musician. And they're like, hey, here's your bill. Here's what we think your bill is, because you have to pay it. And then when you pay ASCAP, then ASCAP uses it, they process it through their algorithm, and then they send out checks to composers. which is great news for musicians, yeah. But people try and get around it, you know. So if you guys have ever worked retail, so yeah.
I would not go to a yoga studio, not something like a show venue.
So they definitely do that. What they do is they pick like areas of businesses and they send their scouts around like based on this like methodology of what they're gonna hit. So like they always hit bars on a regular basis.
Yeah.
So like a really good example of this is ASCAP and BMI are both based in Nashville. So if you walk around Nashville, just like any old bar, like they're so regulated that like they blare their stickers on like for ASCAP, BMI, and CSAC, which is the like third for-profit organization that deals with this, to be like, we are compliant, please don't bother us. So like I feel like for them the venues are almost a given. It's kind of like you walk into a candy shop and they're playing their CDs. You're actually not supposed to do that. If any of you guys ever worked retail, I mean I worked retail and when I was a teenager, and like you have to listen to that one CD for 30 days and you want to just kill yourself. But that's because they actually only license the rights to those particular songs, which is why they play them over and over and over again. Because you can't just broadcast radio because you're a public place. You can do that in your house, but public performance is part of the rights that copyright owners have. So you either have to license it and pay for it, or you don't get to do it.
So is even an independent little store in
Yeah.
Cambridge playing Spotify through their speakers?
Yep.
It's not.
So if you go onto Pandora, for example, they have Pandora One, which eliminates the commercials for personal users, and then they actually have Pandora Business. So, which is basically if you're a public space, you're open to the public in any capacity. Even if, say for example, you only book private events, let's say you're like a banquet hall or something like that. If you have the opportunity to be open to the general public, you're supposed to get a public performance license from all three organizations. Now, in almost all other countries, there's only one. And in America, we have three, which is super complicated for people and very, very annoying. But if you go through a company like Pandora and you agree that like, hey, I can only interact in certain ways with it over a certain period of time, so I think you can interact with Pandora 6 times in 16 minutes. And if you agree to that, then you're covered. So, yes.
So I know, especially in Boston, especially from personal parties, people go out and do busk on the street. That's something that I'm sure someone who knows someone that's done that. Would that not be considered like a public place? If you stand on the corner of like Newbury and Gloucester and you're playing a bunch of covers, is
Not
that
your problem.
still not your problem?
Not your
So I'm not
problem.
gonna get a letter from ASCAP saying
You're not going to get a letter from ASCAP, depending on how it's zoned. So before I even started practicing law, I was with the Volunteer Lawyers for the Arts, which is, by the way, an awesome organization. I'll give you guys some resources at the end, but you should totally seek them out because they're awesome at what they do. But they, like this random, like this town got contacted because they had a gazebo. It was like some town outside of Gloucester. And this woman was like irate because she got contacted by ASCAP and BMI, and they were like, you need to pay us $1,000 for like the community concerts that you have. She was like, this is just crazy. And so the attorney that was taking the call was like, actually that's not how it works. Like, you know, if you're going to have a public venue for someone to play music, you as the venue owner are responsible for that. So playing outside on the street, totally Boston's problem, not your problem. Play on the streets to your heart's content. Please come to Central Square, by the way. Our office is in Central Square. We'd love to hear you. Yes.
Yeah, one question. So you said that retailers sometimes use one CD.
Yeah.
So don't they sign a blanket license where they can use any song from the catalog?
Right. Really great question. So some places do. And even smaller companies will have the opportunity to sign blanket licenses. So they might go to Universal and say like, hey Universal, we'll pay you $3,000 to, you know, well, I don't know. Let me think of like what's a good example of a big but not big business. I don't know. Let's just say you have 5 retail locations, and you're like, hey, we'll only play Universal stuff. Then they are more than willing. They're like, they set a flat fee. They're like, pay a couple of $1,000, like press those CDs. They're only allowed to go into your stores. Really great approach, and you'll have access to the whole catalog. Large stadiums also sign blanket licenses. So like if you go to TD, if you go to, what's it called? I want to say Great Woods, it's not Great Woods, it's gone through like 4 name changes. Xfinity Center. If you go to Xfinity Center, what they do is like the performing rights organizations every year will come in and they'll take kind of a tally, like how many concerts did you have, how many things did you play in between, and they'll quote them a blanket rate. So like if you go to a hockey game at TV, you know, they'll play certain things over and over. And they'll just do one flat fee for that stadium for the whole year based on what they think their attendance and their music playing is going to be. And then that flat fee, they plug it into their algorithm and then send the money out to musicians. So, I mean, they definitely try to be accurate. You know, it's not 100%, but they try to be.
I thought the pair was the ones that issued a license.
Yeah, they do issue the blanket license. So for performance rights, when things are played publicly, the sound recording actually almost never gets money for that, which is why I'm saying it's actually more lucrative to be the composer owner. If you have to hang on to something, God, just let the sound recording go. You'll probably be under some restrictions to re-record it for a certain period of time, but the composition lives on forever and it has many more rights than the sound recordings do. So yes, you're correct. Public performance licenses are actually only issued for the compositions.
What's the difference in cost when a company pays for a CD, like licensing those songs, and like the one where you can use all the songs?
Right. It really, really depends. I can't give a figure for that because it depends on the size of the catalog and it depends on the size of the licensee. So the retail store that is asking for it. You know, do you have 3 stores or do you have 3,000 stores? You know, so the huge differentiation in fee, and there's no like flat rate that you build on based on like any particular location, because it does kind of depend on like for example, let's say you're Hooters and you run like you have sports pubs and you have tons of speakers and tons of TVs and stuff like that. That rate is going to be a lot higher because they're going to play a lot more music versus if you're like, I don't know, you're Bed Bath & Beyond and you like kind of play music in the background, which is a totally separate area. But still, yes.
The thing that you said about everything is negotiable, does that also apply to these things like Songfile, or that gives
No, so Songfile only deals with copy and distribution, so they only deal with mechanicals.
Oh, okay.
And because mechanicals are set by statute, so it's 9.1 cents for each distribution. So that's whether, like, so let's say you're going to only do physical pressings and you're going to do 2,500 copies. Then they give you a rate based on that. But say, for example, if you know you're going to go through iTunes, you actually have to estimate what you think you're going to get for downloads. And once you exceed that threshold, you're responsible as the person that did the cover to go back to Songfile and ask for more licenses. The negotiable stuff, there's no third-party agency that I'm aware of that will handle that on your behalf. Unfortunately, it's like emailing the licensing department, which is super annoying. But yeah, I mean, besides that, covers are great. Okay, yeah. Okay, copyright protection. So, great thing about copyright is it exists as soon as it comes into being. You actually don't have to register. So it exists as soon it comes into quote tangible form, which actually you don't have to be able to touch. It's as soon as it exists somewhere besides like actual live playing. So it has to be recorded or documented in some way. So it has to be written down on sheet music, or it has to be recorded in some way, which includes streaming, which I think is really, really important because it's so momentary. But as long as it could exist somewhere for the teeniest period of time, it counts as copyright protection. But there are additional benefits to choosing to register your copyright. Yes?
So if one was to put a song on a streaming site such as SoundCloud or Bandcamp, it would be immediately copyrighted?
Yes.
All right.
Yes. The first time it is heard. So like probably actually before you upload it onto SoundCloud. I mean, you're obviously going to listen to the track first. Then it would be protected by copyright. I would highly recommend you keep that file. But there are additional rights with registration, which I think is like a big thing for people because they're like, do I register? I don't understand what copyright registration means. Like, does doesn't mean I don't have any protection if I don't do it. It's totally not true. You absolutely do have copyright rights if you don't register, but they are really difficult to enforce. So you cannot, absolutely under any circumstances, actually file a formal lawsuit without a copyright registration number. So what you can do is, you can engage in what we as lawyers call dispute resolution, which is basically like you send a cease and desist, and you're like, hey, not cool, and you try and work it out beforehand, and we basically ignore the fact that it's not registered, we just act like it doesn't exist. And we hope that we can work out some kind of settlement beforehand. And I would highly recommend, at least for the things you know, like if you do an album or if you do an EP or you know you're gonna release something, like we're gonna go over it, but man, like please spend the money to do it. It will make your life easier if there's ever a problem. If there's never a problem, like who is gonna look back on it and be like, man, I'm really sorry I spent that $300 to register a copyright? No one's actually gonna do that. So you can't sue anybody without a registration. And you also, once you get that registration, so some people parse out their copyrights. So let's say you release a song and for 6 months you don't register the copyright. Then you register it, and 6 months after that, you realize that someone has been infringing on it for the whole time period that it was released. When you actually can sue them because you have a registration, you're entitled to statutory damages for the registration period, but not for the time that it wasn't registered. So statutory damages are up to $75,000 per violation. So if you hear about like especially college students that download like 20 songs and someone got a judgment back in like 2010 for like $2.1 million, and you're like, what? That's because they only had to prove infringement. They didn't actually have to prove what they lost. So once you can prove infringement, you are entitled to that $75K if the judge thinks that you're entitled to it. Before that period, while you can sue if you have the registration in place, you actually have to bring forth evidence of the money that you lost. And for a lot of up-and-coming people, that's not really a whole lot of money. So for the $35, if anything really bad happens, you could be entitled to $75,000. Versus trying to prove what you actually lost, which is really difficult to do. The online system is pretty easy. We're going to go over a couple of tips for that. But they still do require physical deposits. So even in our digital world, if you are planning on distributing your music in any physical form, then you still have to send in physical CDs. And we'll go over why things should be registered separately. But the important thing for everybody is that IP protection and copyright protection is static, which means that if you send in a composition, the copyright protection extends to the actual thing you sent in. So if you compose something and it undergoes a substantial revision, I would highly recommend that you re-register that copyright because you're not going to get copyright registration on the additions. The same thing with the sound recording. So like sound recordings are that one sound recording. So if that sound recording is extremely valuable to you and then you record, say, a live version that sells really well, that live version should hold its own copyright because all the government has to go on is what you actually submitted. Yes?
So by substantial revision, that means like the first time that you recorded it and it's already been out for, say, 6 months, and then you think of a new, better way that you want to record the song and you re-record it, what do you do with the other thing?
Right, so you can, so that old registration will always exist. You don't override it, you don't replace it or anything else. But like, let's say for the sake of formality that you're, so I was a classical flutist. And let's say I composed something and then I added this really great extra movement to what I composed. And it wasn't part of my original piece. I would definitely say spend the $35 and register a new copyright. Because that particular movement wouldn't be covered under your new registration. Same with the sound recording. Like sound recordings, like every time they're recorded, like any music that is public mainstream release, like you're gonna see, if you go into the copyright office, there's like a ridiculous amount of recordings for those things. Because every time they change, especially if they're covered by a record company, they're just like, register it, just do it, you know? So any changes, yeah.
When you register for copyright, do you register per song or can you register for like a
Really great question. We're gonna get to that. All right. All right, so tips for registrations. Here's the thing. So music is a business. There's no getting around that. No matter how creative we want to be, at the end of the day, if we want to make money, we have to treat what we're doing as a business. Yes.
On that real quick, if you
Yes.
register a newer version of the song, does copyright for that newer version go away, or does it still?
No, it doesn't. So it kind of depends on, like, did you build on that old version or did you totally do a new thing? Because you actually have an opportunity in your registration process to call out the old registrations and say, hey, this old registration is actually included in my new registration. So you can actually kind of build on it. It's just that you can't go in and edit it. You know, you have to do a brand new copyright. So it's not necessarily that it replaces it. So, you know, if you look at like musicians that have really long careers, they might have 2 or 3 or hell, a dozen different recordings that are really significant. And each of those have value. The newer recording doesn't replace that old recording, you know, or even a new composition thereof, you know, a new version of it doesn't replace it. It just supplements it, I suppose. All right, tips for registrations. So if you're treating your music like a business, you're probably going to deal with a lawyer at some point. I would say that the most basic thing is copyright registration, coming up with how you're going to treat your copyrights. And I would say that it is worth your time to figure out how the Copyright Office treats copyrights and to learn to do that yourself. As a lawyer, that is not the most interesting thing I do. It is not my favorite thing, I will say that personally. But also, I don't necessarily really like charging my clients for that. I almost feel awful because you could totally figure it out. So I would save your money for complex issues. But that being said, I think that and we'll get into band agreements hopefully in a little bit, but everybody wants to give everybody their due, but the more copyright owners you have on one particular copyright, things get complicated really fast. So if you're planning on doing that, and you're planning on like all 5 members of your band holding every single piece of the copyright, then you need to be prepared for the consequences that come with that, because they are complicated, so you need to be prepared to spend time to digest that stuff. So if you go to copyright.gov, not .com, so .com is a for-profit company that will work with you to manage your copyrights. And I'm not dissing them, I'm just saying they're not the government. So, no, they're not a bad company. They're actually based here in Massachusetts, but they are a commercial company. So the ECO, so if you go to copyright.gov, the ECO is the Electronic Copyright Office, which is almost always how you're going to deal with copyrights going forward, despite the physical deposits. There's a tutorial on the homepage in a lovely PDF, and it will like point arrows and show you like step by step how to go through a process and like handle doing registrations. I would highly, highly, highly recommend that you download it. So getting to your point about albums and about comps and SRs, I mean sound recordings, I just got really lazy when I was typing up this PowerPoint. So sound recordings and compositions need different copyrights. They are treated as 2 totally different things. So compositions are works of performing arts, and sound recordings are specifically just that one capture of that particular composition. And they're usually owned by different people. So for example, like if you're an unsigned artist, you're probably going to own both of these. If you recorded it, you're going to own the sound recording and the composition by default. When you start getting involved with publishing companies, your publishing company is probably going to want you to transfer the comps to them right away so they can exploit them, which is basically so they can look for placement opportunities for you, and they don't want to have to ask your permission because it's cumbersome to them. And then for sound recordings, the record company tries to justify it as, well, we're going to pay for you to record this album, but then we're going to ask for that money back, but you're not going to get the copyrights back. So they're always going to own that one particular sound recording, and usually it's registered in their name. So so you have the opportunity to register a composition and a sound recording as one copyright only if they only have one owner and it's the same owner of the song, the composition, and the sound recording, which a lot of times it's not. So that kind of eliminates the whole doing just a sound recording and the composition together. So I think it's probably usually best to think of them as totally separate things. And also albums can't be under one copyright usually. So again, because you have to have one owner, and this is the first thing that the Copyright Office will ask you, they'll take you through this little kind of questionnaire. And they'll be like, is there one owner for this copyright? And if you answer no, they're going to take you to a totally separate spot. Which they should, by the way, don't lie, that's not going to benefit you. It might save you money, but it's not going to benefit you. So it's only if the album has only one songwriter and one owner for every single song that's on the album. Because that usually isn't the case, each song gets its own copyright and then the sound recording gets its own copyright as well. So what you can do is you can take each song and then choose to register the album as a whole in what we call a compilation. So the album itself does hold its own copyright, but then each piece actually has a copyright as well. It sounds unnecessary, it's just unfortunately how they process copyrights. So basically, anytime you write something, you're looking at $35 if you file it yourself. Yes, yes, yeah.
If you, for example, did a collaboration with somebody, like in another country, and you wrote the melody, you wrote the lyrics, you like did a bit of the arrangement, but the rest was there, and it was part of an album. And then the copyright, like it's the only registering that I did was in BMI, was putting it there, but I
Okay.
didn't do this. Is that?
Yeah, so BMI covers one of those like sticks that we talked about, so the copy, distribute, public. So BMI only covers public performance. They don't cover like, so let me think about like a piece of twine that covers the sticks, that's the copyright, it doesn't cover that. So if you choose to register and you want those benefits of registration, which is mainly like you have to sue somebody, that is different than collecting money for public performance. BMI does not mandate that you have a copyright registration at all. And one thing, have any of you guys registered with ASCAP or BMI? Okay. So one thing I just want to throw out there, and I don't know if anybody got confused by this, but they'll ask about the artist and they'll ask about the publisher. And so I get a lot of questions about that, which is like, well, I don't know, publisher, what do I do? Put yourself. You're your own publisher unless you're signed. So what happens is, back in the 30s when they established the organizations, what was happening was the publishers were collecting all the money and they were taking like things off the top. They were skimming before they distributed the money to the artists. And ASCAP and BMI are nonprofit organizations and they were like, no. So what they do is their system is to issue checks directly to the publisher and to the artist totally separately. So they can't mess with those funds, which is why they ask you for a publisher. And if you don't have a publisher currently, then you just enter yourself for both, and you'll get 2 separate checks.
Yeah, so far I only registered as a writer or an artist. So it's like you have to just go through the whole process again of registering as a publisher. Like it didn't ask me in one form. Are you also?
Oh, really?
I don't
You
think
like
so.
register as one, and you register as
Really? Okay, because they used to ask you to differentiate as one
It's
person.
a separate price. So you pay $50.
Oh, good. That's good to know. Okay, don't worry about yourself then. So you get 100% of your pie. That's fine.
So then you wouldn't have to do that. You would have to register twice.
Yeah.
Yeah, well, yeah, if you wanted to get, so what they'll do is if there's no publisher, so if it's separate forms, then if there is no publisher registering for the same work, you'll get the full $1. If we think about it as for every $1, usually the arrangement is that the artist gets half and the publishing company gets half. If there is no one on the other side, then you'll get the full $1. Yeah, so you don't have to register twice. As long as they hold that 50 cents and don't give it to anybody, they'll give it all to you.
Oh, really? I only heard that if you don't register as both, then they don't collect publishing royalties.
I'm not really sure that that's the case.
Oh, really?
Like,
That's awesome.
well, I will double check, and in my email, when I send my follow-up, I will let you know. Because if that is the case, please for the love of go through it twice.
Yeah, no, that's just what I heard. I hope you're right.
I hope so too. If I'm not, I will totally admit that.
Actually, the formal line is like you have a link where you can register as a publisher and as a private artist. So you just choose one and then you fill out.
Yeah, but I don't want them to hold that 50 cents though. I mean, that would be my big concern, is that for every $1 that comes in, if you're unsigned, you should get the whole
Right.
dollar. Like, that's part of holding your
Yeah,
creative
yeah.
control. So,
Okay, good.
all right, I will check on that. All right, yep. All right, so I don't know, have any of you gone through the copyright form on copyright.gov? Okay, all right, so, but still a minority, so this is not gonna be a review for everybody. All right, so they're gonna ask you some questions that I think if you're not used to the copyright form, come out kind of weird. So they're gonna ask you about publication date. So like, let's say, like you're like, well, I don't know if my work has been published. Like I played it at this like coffee house, or I played it for my friends, or something like that. So this ties into public performance. So anything outside of your living room, or your dorm room, or your house, or anything like that is a public piece. Okay, so if you've done that, you have published your work. I'm not going to tell you to lie about your publication date. What I'm going to tell you is that a good faith estimate goes a really long way. So if you can't remember the date of that coffee house gig, do not kick yourself. It is okay. Those things only really come into play if you're like involved in a very fact-specific copyright infringement suit. So, you know, if you estimate the first of a particular month or the first of a particular year, I would say from an everyday business perspective, that's okay. So you can pre-register something, which is kind of a big thing, especially in music now, because things leak. So a lot of like bigger works will be pre-registered, so if they leak, they actually already had the benefits of the registration, which is proving that 75K in damages and stuff like that. But I think it's something to consider, you know, when you're kind of starting out, is that pre-registration isn't always necessary, and it also costs you additional money because you basically have to file a new application once you become published. So usually with my artists that I work with, I say like, you know, let me know when your release date is. I'll gather all the information beforehand. I'll put it on my calendar, and basically within a day or two of the release, I will file the copyrights, so they're protected. So there's also a section for authors and claimants, which is a little confusing for people. So as an author, the author is always the original person that wrote the composition, okay? And the claimant is the person that's actually going to own it. So this comes into play if you're going to have a holding company for your music. So let's say that you personally wrote the song, but like all your music gets dumped into like your band's LLC. Then the claimant would be that LLC. Or let's say you composed for a video game, and then the company that hired you is probably going to own the copyright. Then they're probably going to register it on your behalf. But if you're doing it, then you are the author, but the claimant is the actual game developing company. If it's just you, yourself, and I, then you are always your own author and always your own claimant. Pre-existing material really only comes into play when you have a sample of some sort in something, or you're building on an old work. So let's say, for example, you started out and you wrote like a little small snippet of something, but then it kind of expanded into like this whole like 10-minute work. Then you probably claim your old copyright as part of that, which we kind of touched on, and then you would then incorporate everything else into it. Important thing to remember is that even if you register online, they do require you to send in a physical deposit, so they'll tell you to print a shipping label at the end, and you have to send 2 copies of your own work to the Copyright Office. If you're doing composition, if you can print it out in the program that you composed it in, that's great. If you did sound recording, then you send a copy of the CD. Joint ownership. I just really love this picture of Hall & Oates, and I just couldn't refuse putting it up there. So joint ownership is things I get a lot of questions. Like, look at that stash. What the? So joint ownership and compilation are 2 really important areas of copyright law. So basically, if you're going to write with somebody else, so let's say you're doing some collaboration, are really, really important if you're certainly involved with some kind of group or some kind of band. So joint ownership creates one new indivisible copyright. So every single person that was involved with the project has all the same rights. So what you need to have is you have to intend when you're going into the process that you're going to share it. So when you walk into a room with somebody and you're like, hey, let's write a song, and everyone's like, yeah, then that would satisfy for intention to share. Versus like I come with a piece and you come with a piece and we're like, maybe we want to put these together. There's like actual court cases where like whether or not people actually intended to create a joint work. But if you're kind of like, if you're looking back on it and you're like, yeah, we just kind of got in a room and we jammed and it was great, blah, 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 it's probably joint ownership. So the default, if you guys don't enter some kind of agreement, is that everybody has the right to exercise all the rights. So anybody can exercise the right to copy, distribute, publicly perform, like all these things. If like I come to you and I say, hey, I'd really like to do a string arrangement of the song that you did, and you own it with 4 other people, you can say yes, and you don't have to ask anybody else. All you have to do is share the money. So that's different in different areas of intellectual property law. Like in patent, for example, you can't do that. You have to ask other people. But in copyright, you're allowed to do it, and all you have to do is be like, guys, made $10,000. Like, you get 5, and you get 5, and everybody gets to share. So if you don't write anything to the contrary, which is really, really important, because if you want to deviate from this default, you have to enter a contract to cover that. So there are joint ownership contracts. I mean, I write them regularly, but like if you're curious about them, like they're available online. Just Google like joint ownership contract, and it will give you like a good idea, which is probably a really dry read, of what joint ownership covers or couldn't cover. Because it gets into like really weird stuff where people think they want to share things, but I'm like, what if somebody wants to like do a play? And like, well, no, that's not the question. And I'm like, well, that's in here. So if you want to carve that out, then you need to talk about it with the person that you're creating with. So I think of joint ownership as in like baking a pie, which is where you put all the ingredients together, and once you bake that pie, you cannot separate those ingredients afterward. They are a pie and they are done. And you're never going to extricate the crust from the blueberries from the butter or anything else. You're done. It's a good example. So compilations are a little bit different. So to go back to our baking analogy, compilations are kind of like cookies in a jar, okay? So like I make a really mean peanut butter cookie and you make a really great chocolate chip cookie. And we're going to put them in a jar and they're going to be awesome and we're going to sell them together. And if I'm like, man, your chocolate chip cookies really suck, I'm going to remove them from my jar because they suck. Then I can still move forward with my peanut butter cookies and they're going to be fine. So that's what a compilation is. A compilation is that I come with a finished product that is copyrightable on its own. It actually has its own copyright, even if I chose not to register it. If you choose to register it, that makes it a little bit easier. But I came with my own composition, which is kind of where Hall & Oates comes in. Because someone did the lyrics, and someone did the music, and someone grew the mustache. But the point is that you have 2 distinct works that you then choose to unite in a new copyright, okay? But it's possible to extricate those, and that has to be done by contract. That is not a joint copyright ownership, because joint copyright is like kind of this muddled area where like, everybody kind of did something, but if everybody came to the table with something specific, then it's a compilation. And so it's definitely something where if something existed beforehand, like for example, I'm working with a band right now where someone wrote all the lyrics and the music and someone's doing the mixing and the post and the production work. So that is their contribution. So they're actually entering a compilation, which is going to be the end sound recording results. But the production work in itself and the music and the lyrics are actually the underlying composition copyright. So they're coming with separate copyrightable things. So this is really, really important, like when you're getting together as a group, that you establish, like, is every member of the group truly a songwriter for the purposes of the composition? Okay, or are they going to be what we call 1099s, which is their independent contractors, or are they studio musicians where they're paid under like AFM or some type of union rate or something? You don't necessarily want everybody to have say over everything, and if you don't have that conversation, then by default that might be the case where they actually might get some say. So if you're bringing somebody in temporarily or you're bringing in extra musicians that you don't really feel like truly a part of your group, then you should probably at least have that conversation. Hell, for the love of God, just get it in an email or something, that says like, hey, I understand like you're hiring me at $100 an hour to come in here and play, and I understand that my contribution is actually going to be owned by you. Okay, I want to touch on this really, really quick. I don't know how quick this will be, but how are we on time? Okay. So really quick, because I had a lot of questions about this, which is fair use. So people would be like, I kind of wanted to riff on this and that and the other thing. Like, I can do that, right? Like, I heard I can do this, or I heard I can do that. So really important, number one thing about fair use that you need to shift your thinking about is that it is a defense to copyright infringement. It is not some kind of right that you get to assert. So people will be like, well, how do I know if it's fair? And I'm like, if you get sued, you'll find out one way or the other. Which is not a scenario you want to be in. And so like there are lots of lawyers, for example, that will consult on where they think this line of fair use is. And I'm just gonna put it out there because it is kind of like basically the only thing that people care about in copyright law right now, which is fine because I'm just glad that people care about copyright law. That line has been blurred. It has been messed up. They have taken it and they have like thrown it all out the window as far as like all of us practitioners are concerned. Because we thought we knew where that was, and yeah, they totally did up. Yes. I made a really bad joke. Whatever. Thursday, I'm going with it. So they thought they could kind of like vibe on an homage, and they were like, this is totally fine. It was totally not fine with the gay family. They were not cool with it. So you don't know unless you get sued. So people think, well, I can use like 6 bars of something, or I can use 5 seconds of something. Like, I don't know where they get this. Like, people on Reddit need to like lay off from copyright. There is no rule. There's like this crazy 4-factor test that we'll like touch on in a second, which is kind of dry. But so there's de minimis copying, which is like the teeniest thing that you barely notice. So this de minimis comes in where like something's in a background somewhere, and very, very rarely comes in music. This is like I am in a music video when I'm walking down the streets of New York and someone's like logo is in the background. That's fair use. I don't have to ask every person that has an advertisement in Times Square for their permission. It's totally cumbersome. That's de minimis use. Very, very rarely comes in music. Parody does come in basically every area of copyrightable content, because the number one thing with parody is I had to use it in order for it to be funny. I had to reference the source in order for people to get the joke. Okay? That's not satire. Satire is like, I did it because I wanted to use it as my basis so people thought it was funny. But like parody is like, it had to be done in order for people to get the joke. So like, The Onion is a really great example most of the time of parody. You know, because they'll say something ridiculous about, I don't know, I'm like trying to see so many Onion articles every day. I'm trying to think of like what it was where like, okay. Really modern example is like, there's this off-Broadway show right now that makes fun of Three's Company. So like it makes really specific examples to Three's Company. And it's not funny unless you know Three's Company and you understand the jokes. And then like you derive off of that, and that's what makes it funny. So parody is actually a pretty easy area of fair use. So if you have to reference the source in order to get the joke, it probably fits into parody. The other area where it fits in is certainly in your everyday lives, which is any kind of education, fits into reporting, commentary, and criticism. So if you are criticizing anything, let's say you're a music critic, you are allowed to use small samples of things and reference portions of music. And certainly for educational training, like I probably could have inserted all kinds of sound samples here, and no one's going to come after me because I need to do that for demonstrational purposes. But I think a really important thing is that a lot of nonprofits come to me and they're like, well, I'm a nonprofit. Can't I do this because I'm a nonprofit? And I'm like, no. You know, you have to be fulfilling some kind of utilitarian purpose, I suppose. So if you're commenting and criticizing on something, then usually that's going to fit into fair use. But the test is actually a 4-factor test. So it's actually the nature of the original work, which is like, did you like think of this like totally on your own, or is it the phone book? Is it like the Harry Potter series or the phone book? Like these two things have different creative skills. So if you like riff off of Harry Potter, you're probably going to face more consequences than if you took a couple entries out of your phone book. And so what is the purpose and character of the new work? So this is where something what's called transformative comes in. It's a really, really famous copyright law case that follows Two Live Crew, like riffed off of Pretty Woman. They did like a rap urban version of it. It's like a landmark case. And so they said like it was really transformative and they had to reference Pretty Woman in order for you guys to get the joke about the rap and stuff like that. They actually won that copyright case. But it was like, how much did you change the original work in order to get your point across? Did you just copy it over? There's a famous case where in the early aughts, universities were scanning whole textbooks and uploading them on Blackboard or some equivalent thereof, and they said that was transformative. And the court was like, but you're not changing it in any way. Versus like Google Books was considered transformative because although they scanned everything, they actually added a searchable feature. So like, which was the equivalent of you or I going into the library and pulling every single book off and flipping through every single page. They made things a lot easier, and that was considered transformative. So that's why we scanned. Also, amount and substantiality used, and this is where the kind of 6-bar rule comes in, which is like, okay, I only used a sentence from a book, so it doesn't really matter. But there was a really famous case from like the 80s where the AP, the Associated Press, published one paragraph from Gerald Ford's memoir. Only it was a paragraph about Watergate, which is the #1 thing that people were interested in reading about his memoir. So even though the book was like 270 pages or something, the AP lost because that was like a really juicy detail that people wanted. So just because you take a small piece doesn't mean that it's necessarily fair use if you take a significant piece. Yes?
A lot of composers name their pieces, you know, a quote from a book or something. So is that's probably a case where it's a small enough thing.
And it's also a totally different medium as well, which kind of goes to our fourth factor that we'll talk about really quickly, which is that, you know, if I name a piece To Kill a Mockingbird, that my naming the piece is not a substitution for reading the book. So, you know, so in short, yes, you can certainly pay homage to something, you know, where it's like, hey, I drew on this because I really liked this book, for example. The title in itself. Fair use is weird too because it's also like, no one can tell you 100%, so it's like, oh God, do I open up this Pandora's box by going to the author, for example, and saying, hey, I wrote this piece, I'd really like to call it X. Because like, you may or may not need to ask them. This is where emotions come into play, where some people get really pissed off if you don't ask them. So it's like, you know, if you had just asked me, I would have said yes and I wouldn't have charged you anything. Versus like other artists might be like, you know, well, as soon as someone asks me, I'm going to say, yeah, it's going to be $10,000. You know, it's like the unpredictability of it. So are you better off to like ask and avoid it from the get-go? For example, Weird Al Yankovic has a policy, even though he clearly fits into parody. Like, without a doubt, you need to have the original piece in order to get the joke, right? Always has a policy of asking. And if artists say no, he doesn't record them. Like, he asked Eminem, and Eminem said no, because he sucks. You know, like, who says no? Whatever. But, so he didn't do it. But the point was that he asked, and he said no, and he said fine. You know, so it's like, I would always encourage, I feel like there's a gut reaction to fair use, where if you're trying to play off something, or you're trying to pay tribute to something, there's a gut check. We all have a gut check, where it's like, this feels wrong, or like, I feel great about this, you know what I mean? If it feels wrong, I really encourage you to reach out to the person that owns it and say, hey, you know, I'm just this person here in Boston, I really want to do this, but look, I just want to get my ducks in a row. And honestly, people ask me to do this for them, and like 95% of the time, the artist is like, happy to do it, here's how I'd like my credit line, for example. You know, who isn't happy to give a credit line? So, and the final test is the effect on the potential market, which is, does the new use replace the old use? And if you replace the old use and people are going to you instead of going to the original copyright owner, it's probably not fair. For me, a good example of this is how DJ Girl Talk puts things together, which is like the teeniest, tiniest snippets of everything, like blending everything. I'm clearly, if I want to hear, like, Give Me Some Lovin', I'm not going to listen to that CD instead. It's not a substitute, and it's not going to replace the sales for that music. Yes?
Question. So if someone named their song Stairway to Heaven when it already exists, how does that work out?
Oh, interesting.
So like naming it, or maybe like something that is more like derivative of the name.
Right.
Because it's in the same domain. But
Right.
you know,
So I'm not really sure that that's necessarily covered under fair use because titles are generally not protectable unless they enter the trademark realm. So like this is like your example, for example, I would do a gut check for that, which is like, I'm gonna name my song Stairway to Heaven, you know, just not gonna go there, you know, gonna pick something else, you know. But generally speaking, like if you think like, Hello, I Love You, or something, tons of people, like I look at CD, like, you know, I look at CD lists sometimes and I'm like, huh, is that a cover? Because that is the same name. You know, like for example, I love Dolly Parton. She's like my spirit animal. She is amazing. And so when I search on Spotify for Jolene, for example, so many songs. And like, who am I thinking of that has a song called Jolene? It's gonna drive me. Ray LaMontagne, thank you. And he always comes up, and I'm like, no, Ray, I don't want to listen to you. I want to listen to Dolly Parton, you know? So like, yeah, so there's a bit of a gut check that goes into it. So Stairway to Heaven, I would say, is a very unique and obviously a very iconic thing. So I probably wouldn't go there. But generally speaking, titles aren't afforded a whole lot of protection. All right, so effect on potential mark. One other thing I want to touch on with regard to that is so music, this really revolves around samples and stuff like that when you're talking about fair use. It's a much bigger thing when you're talking about different forms of art. It's one of the huge cases that examines effect on potential market is porn. So the reason that Google Images exists is because they do thumbnails of things. And so this website called perfect10.com sued Google because Google Images had just come out, and if you searched for women on Google, you would get really small images of boobs. And so they were like, well, people aren't going to pay for it if they can see it for free. And so Google effectively proved that no, small boobs, not the same as high def boobs. So they actually won that. And so there actually was a fine art case with this as well, I should mention. An artist was very upset that Google Images was using thumbnails of her lithographs. And then, you know, but the thing is, if you look at Google Images, this is really interesting. Google has like this really cool litigation history because they go into something, like Google like will try anything. They're like crazy. And so they'll go into it and they're like, we can totally do this. And then when they get sued, they're like, no, that's not what we meant. That's not what we meant at all. So like, for example, when you went to Google Images, you used to be able to click on it and Google would actually be the source site that you would go to and you would get the high def image for it. Now you can only see the thumbnail, and when you go to view file or view image, it will bring you to the source URL. So they changed that during the litigation because they were like, just kidding, that's totally not what we meant. So I feel like part of Google's growth strategy actually revolves around getting sued, which is crazy, but really interesting. So, all right, fair use. All right, so we're going to move outside of copyright now, and we're going to go into companies, because a lot of people are like, well, do we need to form a company? Do we need to do something? So I call them entities, because I'm queer, and I use really dorky words. But most people call them just companies when they're talking about all of that. I think the most important thing to differentiate is that people will be like, well, what if I'm the only person? I'm a sole proprietor, right? So I'm in business, I'm a sole proprietor. That's not an entity at all. You just gave yourself a title that means nothing. So you can give yourself a different name if you want, that's fine. It does not mean anything. It gives you no protection at all. So what you do is when you form a company, you separate your personal self from your business self. And it's really important that you respect that line. Because if you don't respect that line, then you might as well have done nothing at all. So sole proprietorships, or people will say DBAs. Oh, I filed a DBA with Boston or something like that. That's just filing a different name for yourself. It's not actually filing any kind of company at all. So a lot of people talk about partnerships, especially if they're with a group. They're like, oh, we entered a partnership agreement. Partnerships are great because they do establish some kind of legal criteria about what's going on. But I think there are a couple like kind of red flags for me with partnerships. So like partnerships are cheap, for example. Sole proprietorship costs you nothing, by the way, but it also separates nothing. So, you know, when you have no assets, that's not a big deal. But, you know, when you buy a house or you get married or you have a kid or something, sole proprietorship is not such a bad idea. So with partnerships, what you do is, let's say that okay, I'm just going to go back to my Hall & Oates example because that's working for me right now. So we're Hall & Oates, okay? And what we are is we're both 100% fully responsible for what we do, okay? And if someone is really pissed off at Hall and the Hall & Oates partnership, they might sue Hall and not Oates. But the thing is that both of them are fully responsible for covering anything that comes out of that, okay? So let's say there's some type of copyright infringement suit and some judgment comes down for like $50,000. Someone that won that judgment can seek it from whoever has the deeper pockets. There's no separation within the partnership as to who they can seek that money from. So you really, really have to trust your partners and be kind of equal. So it's called joint and severable, which means that someone can go after anybody or everybody to try and be made whole. And there's also no liability shield for what we call general partners. So there's also, we're going back to the sole proprietorship, there's no separation between one's personal assets and one's business assets. So let's say I'm in a partnership and really I haven't put a whole lot into the partnership, but I have $1 million house, for example. If someone sues the partnership, there's no separation, there's no line, they can actually go after $1 million home. You also can't trade people out, which is a big problem for creative groups in general, okay? I love when bands are like, we're never gonna break up. I'm like, you're a liar. So you can't trade people out. So like, you're really looking at it from a legal perspective, partnerships just don't work for creative groups because you're gonna need to trade people out sooner or later, most of the time. So generally speaking, I'm a big advocate of the LLC. If you're gonna move forward and you're gonna form a company, I say form an LLC. A lot of people hear about corporations first and they're like, well, I don't understand what this LLC is. I feel like I'd rather form a corporation. So they'll go online and they'll be like, oh, I can incorporate for $90. That sounds great. LLCs are $500. Why would I do that? There are a lot of responsibilities that come with corporations, like under law. If you really want to keep things separate and respect what we call the corporate veil from a legal perspective, corporations are way more burdensome. And in creative industries, for me, when people want to move forward and they want to actually form a business, I want to make it as easy as possible for them. Because their job is to make art. And I don't want their job to be maintaining business records. That's my job. So I am a big, big thing for the LLC. Because in a corporation, let's say you're an only person. You do freelance work, you're a studio musician, you sit in for things sometimes, but you're not really part of a group or whatever. You're like, why would I even bother? I'll just become your own corporation. You have to have meetings with yourself. You have to leave this crazy paper trail. You're like, this meeting hereby comes to order. Yes, I agree with that. We would like to cover the following topics. Yes, that sounds like a good idea. We need to spend $500 to, buy new musical equipment. Yes, I agree with that. And you need to write all that stuff down. These are the true essences of keeping the corporate veil. It's so silly. You have to and you send email confirmations for things. These are things I actually consult my one people corporations to do. LLC eliminates all that stuff. You don't have to keep any kind of crazy records, except that you should make it a habit of keeping records, but the state does not require that you do so. It's just not necessary for bands or any kind of musical groups. I just think that it's silly. Unless you're involved in some kind of investment. So let's say, for example, you get signed to a label and your label is really interested in taking a piece of your company. then okay, we can talk about different stock options and stuff like that. But it's just really not necessary. What I would say is that, like, look, everybody's got their thing going on over here. Everybody's got their personal life. And then you've got your business that you're involved in. You don't want your personal life and your business life to be mixed up. It's really important, I think, mentally, in addition to actually, like, from a legal perspective, that you separate those two. So I highly recommend, like, when you're in a position to form a company, that you do it. I just don't think that a corporation is the right thing. And a lot of people go for it because the filing fees are low, but the maintenance is a pain in the butt. So when I do, and we're going to do band agreements next briefly, when I do entities, a lot of times people are confused because you have songwriters in a band, and a lot of times, like, certain people in the group actually aren't songwriters. So how do you give them credit and due and some kind of payment for being involved in the band, but retain your own songwriting credits? So a lot of times, especially for my unsigned bands, this LLC can actually operate as your publishing sign-up for ASCAP or BMI, which means that something lives, some money lives in the entity and is shared by all the members, but the people that are the songwriters sign up separately for ASCAP and BMI, and they then retain their songwriting ownership and their 50% of the royalties if that's how you choose to split it. And I also say that I've written some pretty, like, interesting provisions about recordings where the people that are involved in the LLC, in the band, at the time that the recordings are done, they reap the benefits of those recordings while they're with the group. And then when they leave the group, like, what I say is cut the cord if it's possible. It gets more complicated depending on how long people have been together. But basically I say, like, your company can benefit financially from it, but there's a possibility of, like, keeping your personal ownership of things without subjecting yourself personally to the liability of it. Alright, whenever we think of band agreements, please do this while everyone is getting along. Because when musicians get pissed off, things get really ugly. We're all artists, we're very passionate about things, and people get mad, and people don't think with level heads about these things. And so, like, I say, if you're gonna enter a band agreement, like, don't do it when the band is not doing so hot. Do it while everybody is getting along. So I'm assuming I write my band agreements almost always from the point of my band having formed an LLC. And so I'm just going to go with this because most of the time I do deal with bands and not classical musicians. So I'm just going to go with that assumption. So the important thing to remember is when you're reading through band agreements, or if you look them up online or anything like that, you're probably going to see something of managers versus members. And what we think of as managers in the music industry is very different from the manager function from, like, an LLC perspective. So LLC managers are the people that, like, oversee day-to-day stuff. So they're people that probably sign checks because they're, like, right there. They're probably the people that are in the business meetings. They're making certain decisions on behalf of the whole group. And they're given certain rights. And it's really important that the group discuss what those rights are, but it doesn't necessarily mean that they own any interest in the company at all. So if you have a music manager or a business manager of some sort, it is totally fine to actually appoint them as your manager in an LLC. It does not mean they own any interest in your company at all. Members are the people that actually own interest, which may or may not have management powers. So you have, like, these, like, managing members that are on both sides of the fence, but the members are the actual people that own pieces of the company. And so it's really important that you discuss that these roles are almost always filled by at least one person or the other. So it's really important that people understand them, and they really discuss what they want the manager to do without their consent, and what gets defaulted to the people that own the company, okay? So we'll just think of them as members of the band. And this goes all over the board for me. So for example, I have groups that, like, they have a business manager that is actually not a member of the band at all. And all they do is, like, paperwork, they book gigs, they collect the money, they write the nasty emails, they do all those kind of things, but they have no musical talent whatsoever. They're not involved in them at all. And so we're very specific about the things that they're allowed to do. We kind of lay these things out in the contract and say they're allowed to authorize like a one-time expense of $500, but no more than $2,000 a month or something. You know, and as things start to progress, they'll get more complex. And then certain things are like every single person in the band is a manager and they're also a member. But it's like everything will always go to a member vote. Like I have certain things where certain groups are like, we always need to 100% agree on everything. And I'm like, that sounds difficult. And they're like, well, that's the way we want it. And I will draft it if that's the way they want it. But usually it's a majority that people want. But then there are certain circumstances where they're like, well, if we're going to kick somebody out, for example, we need a higher vote, you know? So it's kind of like a prenup, I guess. So you plan for things before things get bad, because what you get to do is you get to blame the paper at the end of the day. Because you can just be like, dude, it's not personal, it's just already written down. I mean, it obviously is personal, but the thing is you want to place the blame on the paper. So specific things like for my musicians that I deal with is ownership of equipment, for example. So computers, guitars, amps, speakers, mics, all those kind of things. Are those things that the company is going to own, which means that if you leave the group, you might not get them back. Or are they things that you're personally going to own? So it's really important that you think through these things. Like, for example, like instruments, always non-negotiable, belong to the person that brought them there. But it's really, really important that you think through these things, especially say if you swap off equipment, like then who does it truly belong to? Like maybe you bought it for the benefit of the group, but in your head, you're clearly going to take it with you. But if you didn't specify, maybe the rest of the group feels like you bought it and then kind of donated it to the group. So it's the misunderstandings that always get people in trouble. It's the things that you don't write down that get people in trouble. So I urge you to think through equipment in particular, and then we need to think about compositions and sound recordings. Again, because not everybody always writes, so how are we going to treat that? And almost always what I do is I encourage my songwriters to retain their personal copyright and license the copyright into the company for the company to sign on its behalf to exploit the copyright. So let's say you get a placement in a podcast of some sort, and you know, I don't know, a company on YouTube contacts you and they're like, hey, we'd really like to use your music as an intro to our podcast. We'll pay you $5,000. We're going to do at least 100 episodes. Okay, cool. Then the LLC can sign off on it because, again, like you're thinking about like, okay, I own this, but like I want the company to represent me because if there's a problem, I want them to go to the company. I don't want them to take my house. I don't want them to take my car. You know, like I don't want to have to explain this to my spouse. Like it's really going to suck. So, you know, you want the LLC to sign on your behalf as often as it possibly can. There's a reason you set up that company. It's to protect your personal life. And also, I usually set up those licenses to be revocable, which means that if and when the person leaves the group, certain rights as far as the ownership of the composition leave with them. And not to get too nuanced, but the way I usually set it up is that any agreements that were signed by the company while the compositions were licensed, those agreements have to stay in place. And the person that agreed to that has to continue to agree to that agreement that was signed, and they're going to see it through because that's the only thing that kind of makes sense. And then with the sound recordings, there's a couple of different ways I do it. If there's a producer involved, sometimes I do a license. But if it's just like a group that then went to a third-party producer that doesn't own any interest, then a lot of times I say, hey, let your LLC own the sound recordings. Let your LLC collect that money and distribute it out to everybody. You know, everybody participated in the recording and most of the time, and when they're a member of the band, then let's let everybody benefit from those sound recordings. That's the easiest way to do it. I mean, there's you know, 1,000 different ways, but usually that's what I default recommend to keep things simple. One thing is that people don't always start companies at the very beginning of their musical careers, and so a lot of times there's transfer that's involved, which is like, hey, we recorded this album like 3 years ago, but now we want the money to go into the company, so there's a bit of transfer that's involved, and also what are you going to do with their future stuff. Really, really important that you lay out kicking members out and admitting new people, because it is probably going to happen at some point. I mean, it happens in normal businesses every day. There's no reason that it doesn't happen in bands. But how do you treat that? Like, what do you do? Like, one of the circumstances where you can just tell someone to leave and you don't get anything, and one of the circumstances where you're going to actually have to buy them out, where you want them to leave but they haven't actually done anything wrong. They have violated the agreement. Those are two different circumstances. And also divorce, separation, and death. Which is a big deal. I mean, I think a really great example of this is John Lennon and Yoko Ono. Like, she owns all those copyrights and she has administered them far longer than John Lennon ever did. And so the Beatles basically gained a fourth member back in Yoko Ono because she has so much say over his copyrights, which is, how you want to deal with this. And this is a big discussion for musical groups, which is, if you're in it for the long haul, I mean, someone could get hit by a bus tomorrow, and all of a sudden there's no. So if someone leaves or someone gets divorced, for example, like all those assets go into part of the divorce settlement. And the last thing you want is like a divorced couple fighting over a mutual agreement of music licensing. That is like the worst thing ever for you. No, exactly. Or like if someone dies and like their kids are absolute nightmares, they know nothing about music. Like this happens all the time. I mean, like a great example of this is the Marvin Gaye estate, and Marvin Gaye's dead. So I mean, his kids are overseeing his estate, and so it's like they're making decisions about his music. No, it's cool. It's cool. They're making decisions about his music where we don't really know if that would have been his thing. So some of my bands, like what they want to do is they override the wills and they say like, look, we don't care what your will says. It's not going to go to your kids. What's going to happen is when you die, your interest in the music gets distributed among the people that are left over as the copyright owners, which is usually a lot easier.
What if by some freak accident they all die?
They all die like a plane crash, like a Buddy Holly situation.
Yeah. Like, they're on their private jet to show and they all crash.
So here's the thing. So if there's no will, there's still a statute that covers it. It always goes to somebody somewhere. It just doesn't get like blown up into oblivion.
Like a chain.
There's definitely a chain, right? So it would go to the survivors until there's no survivors left, and that last remaining survivor, if they didn't have a will that covered what to do with that, and it was still under copyright, then it would proceed by statute, which goes spouse,
Someone has
kids.
a will that covers it.
Yeah. But I think it's more like when you have remaining members, like, do you really want to talk to like so-and-so's horrible spouse?
No.
And so usually like divorce, separation, and death, we treat things as personal assets, which is like, it's not a shared asset at all. So if you get married or you get divorced or anything, your spouse actually doesn't have any interest in it at all. We also do kind of a hybrid sometimes where the remaining heirs wouldn't have ownership, but they might have rights to the money, for example. So if someone wanted their legacy to live on as far as the money was concerned, then the remaining members of the band, as part of the band agreement, might agree to remit that money to the family, but not any ownership or creative control, which is also a nice compromise. All right. Okay. No, where are we at? 8:30. Okay. Okay, so we're not going to get to trademarks, but I'm actually not that I'm not that. I'm going to send you guys all this stuff anyway, by the way, so we're not going to get to trademarks probably, but just okay, so I'm going to try and, I think I'm actually going to, I might skip the Sony Pictures license. This is still a good example. It's wicked short. Just keep it for your reference. So this is something that I actually got from a client who got an actual song placed in this particular movie.
Oh, it's just stuff the art too.
Yeah.
It's a real movie. You've never seen stuff yet.
So
It's actually a movie.
yeah, watch out.
Yeah.
Big stuff here. But I think that when you start exploring licensing opportunities, and especially if it's pretty common to get offers from large network television shows. If they're interested in something and like MTV sends out things like this very customarily. Discovery Channel, and they own multiple networks, will send things out like this. They're going to be very short, they're going to be very brief. They're going to give you a very, very small amount of money. And if you look at the contract, it's basically like, we have a non-exclusive license to do anything we want with it. So it's something to think about, because what you have to do is you have to weigh your promotional opportunity with the actual income. So, great example of this is whatever the one-hit wonder band was that ended up with the theme for Friends. They literally got paid $5,000 one time. Okay, yeah. And that was it. And they got syndicated for like ever, and now it's on Netflix, and they're probably sitting on their couch in their underwear being like, what did we do? But like, they were you have to weigh the promotional opportunity with the actual money that you're getting paid. So if you say, you can't negotiate this license, the one I'm showing you is take it or leave it. The same with any network television that's going to present that to you. Is you can take $333.30, or you can not have the opportunity to have your song in this movie. They'll give kind of an idea of what they think they're probably going to do with it. They also don't have an obligation to use it, so they can pay you the money and never use it. And they can use it in any way. So I think it said like up to a minute or something like that. And in the background, which was nice of them to specify, which basically says we won't use it as the title piece, for example. But it really depends on the company, because people are sneaky. Which basically we can cut it into any scene and do anything we want, and all of a sudden you're like beautiful ballad about your girlfriend, so all of a sudden you're into the scene where someone's getting beaten to death. So you really have no creative control over any of that. Huh? Yeah, it's very tender. So I think it's people that you don't necessarily think about that, because you look at it and you're like, oh my god, this is a great opportunity, it's gonna be a national release, blah blah blah, and then like you bring all your friends to the theater and you're like, oh god. So it's just something to think about, that a lack of words isn't always necessarily a great thing. A glut of words is not necessarily a great thing either. But it's something to look at, like, okay, if I sit down and I read these two paragraphs, like, it's so simple. Let me think of all the scenarios that aren't even covered by this, which is kind of like my job. Like, that's like my everyday thought process. It's like, what could possibly hit the fan with this? And then I add additional language to make things not do that. So this is definitely a take it or leave it deal, but it's a good example of kind of a starter basis of what you might see. So I kind of wanted to give that to you guys just so you understand. So for, oh yeah. Okay. So this music licensing agreement is a personalized agreement that I did for a client for a specific project, which I'm hoping will be useful to you guys. There's a lot of money in this. So enjoy. So I had this, I would think one of the great places where this is actually applicable, this was for a literary project, but I think this is a really great example of what could be used for a video game project, which is like, hey, we're putting together this whole big project. We don't really know what it is yet. Let's say it's a video game, okay? And I want to use your music as some capacity, and the developer might not even know what that capacity is yet. So there's only so much they can write down, okay? So what I usually do is that when I do music licensing, again, we want to address both the underlying copyright and the sound recording if we can, and we want it owned by one person if we can get it. But I think that the really, really important thing is the non-exclusive. Anytime you're licensing your music, make sure that the language non-exclusive is part of it. Exclusive should only be in a really big deal where they are giving you a lot of money to make a lot of money. And then the follow-up to this here was the limited exclusive license. So my client wanted to make sure that the music that they were using was not used in something competitive for a certain period of time, also really, really normal. So this client was writing a series of children's books, and they didn't want the song used associated with any other children's property for like 3 years or something like that. Totally normal. You would see that as well if you licensed your music. So let's see. My husband used to work for an advertising agency that represented Dunkin' Donuts, and when they would enter licensing agreements for music, you wouldn't be able to license your music to any quick serve restaurant for a certain period of time. Very common. It's just you want to be kind of aware of those things. They'll almost always ask for your name and likeness, which is fine. That's good for you. I mean, they need to give you want them to give your name and your credit and stuff like that. I would say what I usually ask for if I'm involved in the situation is that it's what's called approved name and likeness, which is basically like as a musician, you have to send them the file. They can't Google it and pick like the horrible selfie that you took last week. Which is becoming more and more of a concern because people are lazy. Which is like, you've got some kind of music supervisor who needs to like get something to a third party and they're like, whatever, I'll just look up their name, and you're like, that looks good. You're like, that's fine. It's the only picture I can find, it's good. So these things matter. So term is usually as long as the project exists. A lot of times we don't know how long these projects are going to go on, so don't be surprised if they ask for that. It's just, you want to weigh that term with your limitations. So if you're restricted for a certain period of time for licensing your music in different ways, like you need to think like, for example, let's say you play the xylophone and you are popular and in children's lullabies. Like you may not want to restrict yourself for 3 years in that particular area. That could be very detrimental to your career. So you need to balance that with your restrictions. Did someone raise their hand? Okay, warranties and indemnities. Really, really like basic stuff. You will see this in every contract if anyone that knows how to write a contract wrote it. Which is, hey, I promise that I have the right to enter this agreement. I promise that everything is free and clear. I promise that I haven't infringed on anybody's copyright. I promise that I'm not lying about anything. I'm promising that I'm not submitting anything obscene. These are pretty easy things, unless you're in like hip hop. Then things become a little dicey. And let's see. And also indemnity is like a fancy word for like, all right, so let's say you license this to, since we're talking about children's properties, let's say you license this to like Sesame Street or something. And then you messed up and you didn't get a clearance for a sample. And they used it on Sesame Street and the Rolling Stones are like, hey Sesame Street, you didn't clear that. And they're like, yeah we did, we signed this agreement with this artist. But Sesame Street has all the money, so even though it was your mess up, they're going to sue Sesame Street because Sesame Street has money. If it wasn't Sesame Street's fault, that's where indemnity comes in, which is when Sesame Street gets charged or gets a judgment against them for copyright infringement. Sesame Street's going to be like, yo, indemnity, this was your fault. So indemnity clause covers when it's your fault and someone else needs to be made whole. So usually these are equal, which means that if you happen to have deep pockets and you licensed it to somebody that had nothing and you got sued for their mistake, then you would be able to invoke that to be made whole. So it's just like, hey, if it wasn't my fault and I get sued because of your mess up, then I get my money back. Breach, care, and termination is just a way to be like, hey, if we fight about something, we're going to talk about it before we actually get into litigation. Dispute resolution and controlling law. Let me say it. That I realize there's a page missing from this. There's totally 100% a whole page missing from this. Can I not put it in here?
If it's missing from more than one, then it was missing, period.
Yeah, it's okay. I'll send you guys a digital copy. The rest of it is what we call boilerplate. So it's just really, really boring stuff. But like stuff where like, hey, if I get sued, where am I going to get sued? Which 99% of the time, these things do not get into play. But like if you get sued and you're like, hey, I live in Boston, why do I have to fly to California? It's because you signed a contract that said that the jurisdiction was in California. All right. So little sample, and I'll send you guys a digital copy so we get the additional page. But I think that something that we want to talk about that isn't included in there, because I think that was a gratis license, is how much are you going to get paid, which was in the Sony license. It's usually a flat fee. You're not going to see royalties until you're like John Williams, and you actually get a share in like box office tickets. Okay, and royalties are actually really complicated to keep track of. So I'm not a musician anymore, and I'm a lawyer, not a business strategist. But I would say if you can get a flat fee and your music can get exposed, there's a possibility that other opportunities will come your way. So accepting a small flat fee for something doesn't necessarily mean that you're giving away the farm. But what you want to pay attention to is if you're doing royalties, are you getting net versus gross? You're probably getting net, which means they have to take all of these things out before you actually get your money, which sucks. But like, you need to really, if you're getting net, like, please just ask the lawyer to review it so you understand what's being taken out before you get your money. And then you have audit rights, which is like, hey, I feel like so-and-so is being kind of shady about what they're paying me. Usually you have a right to hire an accountant to go in and look at the books. Big thing is creative control. A lot of smaller licensing agencies, so there's Babelfish and there's a couple other like licensing agencies throughout the country where their whole job is to just collect music and to try and place it places, right? A lot of times they will work with you with creative control. So you actually could, a lot of publishers and licensing agencies I know will actually say, hey, I'll run this by my artist before I do it. Because like you might have a moral problem with your commercial being, or your song being used as a video that's going to be on, I don't know, a Mormon Bible page. I don't know. Like, let's go the completely opposite direction. You know, so it's like if you can build in creative controls, you're actually getting controls over extreme examples. You know, I'm automatically thinking like dirty things, but maybe it's like you really don't like certain religions, so that's fine. So you can build those things in, and third type cleanse and indemnities, we just covered. Go. Okay. I'm gonna skip this. Okay, what do we got for time? We gotta wrap up. 10 minutes. Okay, I can totally do trademarks in 10 minutes. All right. So the slide that I'm skipping is for freelancing. So if you are a freelance musician, you might have an independent contractor agreement. Basically, what you're promising to do is make sure you get a fee in exchange for the fact that you're giving up your copyright ownership. It's almost always the case. You're being hired to play or do something. You're not being, and you're getting your money, and then they're going to own it. But the number one thing that I fight with people about is if you don't pay my musician, you don't own the copyright. So that is, but it goes a long, long way if you have to fight with somebody about it, okay? So I would say like use that in your arsenal, which is, hey, I signed a contract to play for you, and you own the copyright in exchange for my money. I did not get my money, so I'm not going to let this go, okay? I'm just gonna leave it at that for now. Trademarks versus copyrights. All right, so we touched on this really early. But trademarks are brand identifiers, so you know where it comes from, okay? You get a consistent experience every time you pick up something with a particular like logo or name on it, okay? Not the same as copyrightable expression, okay? Sorry, I'm going to show you guys. All right, so source identifiers, okay? I do have sounds for it. I don't even know if they'll come up though. Can you click on it? Oh, darn it all. Darn it. Okay, you guys know where I'm getting at. You know exactly what that sound is. Okay? So source identifiers are about consumer protection. So the way we think about copyright is that we're balancing kind of the public interest in consuming art to your right to have creative control over the art that you created. Okay? Trademark is almost always about the consumer. What does the consumer see? What does the consumer feel? What is the experience they get when they pick up something that has an identifier on it? Okay? So like Pillsbury Doughboy makes me feel really warm and fuzzy, okay? But it's not just necessarily about words or logos. It can also be sound, it can be packaging, it can be color. Pillsbury Doughboy, trademarked. You cannot have a baked good that goes, woohoo! That is a trademark violation. And it can also be packaging. If you sell jewelry, you may not box anything in Tiffany blue. You may not use that color. So it's really interesting because it can go into these really nuanced areas. So not like such a huge thing in music necessarily. So a Victoria's Secret bag, for example, also the coloring is trademarked. If you sell lingerie, you may not do it with the dark and the pink bag with it. Let me see what else. There's one more. Louboutin, Christine Louboutin shoes. The red sole is trademarked. But it's really interesting too because there's certain colors that you can't trademark, like Pepto-Bismol, for example, tried to trademark the color pink for medicine, but there are only certain colors that people will eat. So they actually couldn't get it because there are medicine colors that people will not consume. I'm not going to name those colors, but we can probably think of those, okay? So they couldn't get pink because there is a limited rainbow of color of things that people will actually eat. So the thresholds are very different. And when I say that sounds can be trademarked, I don't mean you can trademark your song. You can't do that. That's not how that works. It's like the NBC chimes are trademarked. And every time you see the peacock with the NBC, you hear NBC, and that's a trademark. But it's very short, it's very concise, and it's always associated with that particular brand. Yep. All right, but I think the important thing for music is that you have word marks and you have design marks, and there can be multiple things that are associated with your musical product, if you will, okay? So I picked the Grateful Dead because they have several trademarks that they work with, also the Skeletons, which I didn't put up here. But the Grateful Dead as a name is its own trademark. And it's very important to understand that from a trademark perspective, these two things only overlap because you know that from market perception, okay? In a registration perspective, the fact that the Grateful Dead has nothing to do with the teddy bear. There's no crossover at all. This is a drawing, it does not say the Grateful Dead, not reference Grateful Dead, same thing here. These two things have nothing in common as far as the database is concerned, like the USAT database. It's also done by country, which is a really important thing to consider if you start operating substantially in an international market. So like with music and video games, for example, a big crossover is the US to Japan. And so it's really important that if you're actually going to enter that different market, that you look at trademark there. So the Racketeers had a big problem because all of a sudden they got really big and they went to file their trademark in Australia, and there was already a Racketeers group that was operating that had a registered trademark in Australia for live performances. So when they tour in Australia, they are known as the Sadowskis. That is a true story. You can look it up. But all these things come with time. I'm sure they didn't like deliberately avoid it or anything like that. It's just that somebody had. So we're a first to file. So we're a first to use country here, but most countries are first to file. So even though no one knows who the Australia Racketeers are, they still had superior rights to Jack White's group because they were the first to file. So filing with trademark matters a lot more in different countries than it does in ours. We're a marketplace. So same thing, like copyright, it is static. So if you substantially change something about your logo, then you need to file a new trademark as well.
So like when the Grateful Dead puts different patterns on the bears, or like there are all the different images of like bears in different positions, each of those is separately done?
No. So color is a really interesting thing. Because color has its own specific area of trademark protection, you almost always file your logos in black and white. If you want to file them in color, you have to abide by that color all the time in order to get the protection. So if you display it in a different color, you actually don't get the protection. So 9 times out of 10, because most logos will switch out colors, they'll file them in black and white. Really great. Okay. One more?
No.
Oh, okay. Okay, so when you're naming things, so what you can't do is you can't protect something that is generic. So generic is actually something that used to be a trademark that isn't a trademark anymore. So thermos, not a trademark anymore, used to be a trademark. Aspirin, not a trademark anymore, it used to be a trademark. It was actually a specific type of medication owned by the Bayer company. And now aspirin is just like a generic medication, okay? Jacuzzi, not a trademark anymore, it used to be a trademark.
It expired?
No, people started using it in real language. So like certain companies have launched campaigns. Xerox, in the 80s, this was a big problem because people would pick up sheets of paper and be like, will you Xerox this for me? So Xerox actually had this whole print campaign where they were like, it's called photocopying. Please do not call it Xeroxing, we are a brand. So can anybody think of a company that is kind of running into a problem with this?
Twitter.
Huh?
Twitter?
Tweeter, is it, you mean Twitter?
Yeah.
My thing is, if you're going to search for something on the internet, what do you tell somebody to do?
Google it.
Even if they're not going to use Google, right? This is a problem for Google. Because now every internet search, even, well, I mean, who goes to anything but Google, really? But even if you go to Bing. Yeah, okay. Even if someone says Google it, they mean go look it up on the internet. So this is becoming a big problem. When a trademark becomes a verb, that is a problem. So, or a noun of some sort. Yeah, no, you will lose your exclusive rights to it. You know, Kleenex, for example, Kleenex brand facial tissues. Band-Aid brand bandages. And now you'll hear these things on commercials, and they will drive you crazy.
Oh my God, they have it in the song. Band-Aid brand is actually in the song.
Yep, I am stuck on Band-Aid brand because Band-Aid stuck on me. They used to just say Band-Aid, and now they say Band-Aid brand.
Yeah.
Okay, yeah. Now you will be able to hear nothing but that now. Welcome to my world. So yeah, you need to be careful about it because people like this brand recognition. Google was like, wouldn't it be great if we were like the way to search for things on the internet? And they're like, well, shit now. So you also can get
Exactly like that.
Right?
I'm sure that's exactly what they said.
I'm sure there have been meetings about meetings to have meetings about talking about trademark issues like Google has. But you also can't get exclusivity on descriptive things, okay? So like, let's say, for example, my company is called New Leaf Legal. I actually didn't file the legal part of our mark because we provide legal services. It was useless for me to try and get protection on that. Your competitors need to use, so if you have the word music or band in your group, you're not going to be able to enforce that against other people because obviously those are normal words to describe what you guys actually do, so you can't do that. So just a good example of this is the band, who have fought long and hard to get exclusive rights over their name. And also, you can't have things that are misleading. So the band of Montreal, which people thought were from Montreal, are actually from Athens, Georgia. They just wanted people to think they were from Montreal. So they actually had some trademark problems because it's what's called geographically misdescriptive, which is people thought they were from a place where they actually weren't from. Kind of like how people think that Leonard Skinner is actually from Alabama. They're not, they're from Jackson, Florida. So interesting problem when your brand is your own name. So I actually ran into this specific brand where one member was using their last name as the whole band. So there were trademark issues there as far as ownership goes, but you actually have to prove it. I actually had a woman come to me whose name was a name of a well-known home goods person. Let's just call her Marsha Lewitt. And she didn't do anything but she wanted to come up with a cookbook. And she was like, but it's my name. And I was like, I totally get that. But someone else beat you to it. So that can become a problem. I would not urge you to use your own name if you have a name that someone else has already decided they're going to put in the marketplace with. Where you want to be when you're thinking of a band name, I know this is a really big thing for people. I dated a musician for a really long time. God, did he come up with a lot of bad band names. So there's suggestive names, which are like, you have to get the joke in order to understand it, okay? So like Metallica, not really metal, but like, oh, okay, I get it. You know, it takes you a second, but you get there, right? So you want to at least be some kind of like suggesting something without blatantly throwing it in someone's face, like classical violin group. Like people are going to pick up on that right away. But you know, if you do like flings for strings or something, then that would work. That would be a suggestive trademark. Arbitrary is really where most band names, which is like, it makes no sense at all. And, so Imagine Dragons was the first thing I thought of, and so I just wrote that down. But obviously there's 1,000,001 arbitrary band names that you're like, where did you think of that? And I swear to God, they make up most of the stories to try and sound cool. And fanciful are things that are not real words. So Coachella is a good example. It's not a real word, they made it up specifically for that. So I struggle with a lot of this with bands or with brands in particular because they want to be recognizable right away. But also like if you do something that's not recognizable, it's like such a better protectable trademark. You have to build your brand recognition, but it's a much better trademark. Things to consider: marketplace impression, cultures, translations, and epic trademark fails. So my #1 favorite example is the Chevy Nova. that came out in the late 70s, early 80s. Obviously, well, I'm assuming that some of us speak Spanish here. So they tried to do this in South America. Who would buy a car called the Nova? No one would buy a car called the Nova because the music doesn't go anywhere. So horrible, horrible trademark fail. No one did their market research. There's also this really, if you go to boardpanda.com, I didn't display this, but if you go to boardpanda.com, they have an article about epic trademark fails, which are extremely inappropriate, which is why I couldn't post them here. But it's basically all nonprofit organizations that look like they're doing bad things.
Wait, what's it called?
Board Panda.
They come out like in
They use- Yeah, go to like, just like Google epic TM fails and you'll find them.
Okay.
They're
Yeah,
fun.
right, like-
Alright, one more. One more. Let's do that one more. Someone else one more. Oh, okay. Alright, this is the thing I want to cover for you guys really, really, really quickly. Resources. Alright, if you haven't read All You Need to Know About the Music Business by Donald Passman, please, please, please do. It is a super duper easy read. What I'm saying right here is gone into even more detail and he is not boring. Well, I don't think he's boring. So it's essential if you want to even try and digest it. And it's super easy. Unfortunately, I think his last edition was in like 2013 or 2012, which bums me out because there's been so many technological advances since then. But it's totally worth a read for basic copyright law stuff. Donald S. Passman. This Business of Music, also their last edition came out in 2012, but they have sub-hubs. They have this Business of Songwriting and this Business of Promotion and Touring, which are more recent. Also, Music Law, How to Run Your Band Business. Any of these are really good resources if you're looking for more. If you need help or you have more questions, the Recording Artist Project at Harvard, really, really awesome. The copyright professor from there that sued the RIAA a couple of years ago, he started this out. It's awesome. Their blog is a really, really great resource, totally digestible. Volunteer Lawyers for the Arts. I started with them. They're a part of the Arts and Business Council. Don't worry, I'm going to give you guys a copy of the presentation, so you don't need to, I mean, you can if you want. They are really great. They have an entry fee, like per legal issue, but if you qualify for pro bono, which is basically at the time I was there 10 years ago, it's if you make under $30,000 gross, you can get free legal services. And I'm talking like top tier law firm lawyers that are just really into entertainment law and do that shit for free. Okay, so awesome, awesome place.
I think it's priced on the lead, like the price or something.
The project?
Yeah.
The what? Oh yeah, no. It's not his name. I can't remember what his name is right now.
Okay.
There's a gentleman at Sonic Bids called Jamie Davis Ponce that writes only, a woman at Sonic Bids that writes only about legal issues. Full disclosure, my husband works for that company, which is why I found out about it. But I was really impressed with her blogs. They were really, really great. So about like trademarking, licensing, how to record a music video properly, really, really great digestible stuff. Future Music Coalition, really, really, really awesome. They fight for musicians' rights every day. They like lobby and do really, really great things for musicians. And then the American Federation of Musicians, especially if you're a session musician or you frequently go in for recording sessions, the AFM is a really great way to make sure you get your proper rates for things. You can participate in collective bargaining and stuff like that. So depending on what kind of musician you are, also a really great resource. That's me.
Can we have a huge hand for Shannon?